Today on Bench Briefs, we're looking at a case that grapples with a difficult balance: how to protect vulnerable children while respecting the constitutional rights of parents. Ontario Attorney General VG is a 2020 Supreme Court of Canada decision that tests the limits of government intervention in family life when children's safety is at stake. At the heart of this case is a provision in Ontario's Child, Youth and Family Services Act that allows child protection authorities to take children into care without a court order, but only in urgent situations. Imagine a scenario where child welfare workers believe a child is in immediate danger. The law gives them the power to step in quickly without waiting for a judge's approval. This can be crucial to prevent harm, but it also raises serious questions about due process and the rights of parents. In this case, the appellant, known only as G, was a parent whose child was apprehended under these urgent circumstances. G challenged the law, arguing that the ability to remove a child without prior judicial authorization violated constitutional protections under the Canadian Charter of Rights and Freedoms. Specifically, G pointed to rights related to procedural fairness and protection against arbitrary state action. After all, taking a child away from their parent is one of the most drastic interventions the state can make, and it must be done carefully and fairly. The Supreme Court was tasked with answering a crucial question: does the law, as written, violate the Charter by allowing children to be apprehended without a prior court order? In other words, is the statutory scheme a justified infringement on parents' and children's rights, or does it give too much unchecked power to child protection authorities? To unpack this, the court looked at several key issues. First, they examined whether the provisions struck the right balance between protecting children's safety and respecting constitutional rights. Protecting children from harm is a compelling objective, but it must be done in a way that also respects the fundamental legal protections guaranteed by the Charter. Second, the court considered whether the safeguards built into the law were sufficient. For example, after a child is taken into care, the law requires a quick follow-up court hearing to review the apprehension. The question was whether these procedural protections were enough to compensate for the absence of a prior judicial authorization. Ultimately, the Supreme Court upheld the law, finding that the urgent apprehension provisions did not violate the Charter. The court recognized that in situations where a child's safety is at immediate risk, waiting for a judge's approval could cause serious harm. At the same time, the court emphasized the importance of prompt judicial review following the apprehension to protect parents' and children's rights. This quick review acts as an essential safeguard against arbitrary or unjustified removals. This decision matters because it clarifies how Canadian courts balance individual rights with the state's duty to protect vulnerable children. It acknowledges the reality that child protection workers sometimes need to act swiftly to prevent harm, but it also insists on robust procedural safeguards to ensure fairness. The ruling reinforces the principle that while the state has a vital role in child welfare, it cannot ignore the Charter's protections for families. Ontario Attorney General VG serves as a reminder that the law must carefully navigate the tension between urgent action and constitutional rights. It highlights the ongoing challenge faced by courts, lawmakers, and child protection agencies across Canada: how to protect children effectively without trampling on the fundamental rights of parents and children. Thanks for listening to Bench Briefs. Join us next time for another episode where we break down important legal decisions shaping Canada's justice landscape.